Robert and Patricia had done everything right. Married 44 years, 2 kids raised in the same house in Kernersville, just outside Winston-Salem. That house, a 3-bedroom brick ranch on a quiet street, had been paid off for 11 years. No mortgage, no liens, no debt of any kind. Just a clean title and decades of memories built inside those walls. Robert had worked 31 years at a plant in the Triad. Patricia had spent 2 decades as a teacher's assistant at an elementary school in Forsyth County. They were not wealthy people by any stretch, but they had done what every working family dreams of doing. They had paid off their home. They had saved modestly. They had built something real. When Robert had his stroke at 74, everything changed overnight. The rehabilitation facility in Greensboro was $9,800 a month. Their Medicare coverage ran out after 100 days. Their savings, $47,000, were gone in less than 6 months. And when Patricia went to apply for Medicaid to help cover the nursing home costs going forward, she sat across from a caseworker who handed her a form and explained, quietly and matter-of-factly, that the state of North Carolina would be placing a claim on their home after she and Robert were both gone. Not renting it, not temporarily holding it, claiming it, to recover every dollar Medicaid had paid for Robert's care. Patricia told her daughter that night that she felt like the floor had disappeared beneath her feet. She said she kept thinking, "We paid for that house. We paid for it twice. Once with 30 years of work, and now apparently again with Robert's last years of dignity." Their daughter called me 3 weeks later. This is what I told her, and this is what I want every family in the Piedmont Triad to understand before they are ever sitting across from that caseworker. I am going to walk you through exactly what Medicaid estate recovery is, exactly how it works in North Carolina, exactly what it can and cannot take from your family, and exactly what steps you can take right now, this week, to protect what you have built. Stay with me. This is the most important financial conversation most Triad families never have until it is already too late.
Let me start with the basics, because most families have never heard the term Medicaid estate recovery, and the ones who have usually misunderstand what it means. Medicaid is a joint federal and state program that pays for long-term care, nursing homes, assisted living facilities, in-home care, for people who cannot afford to pay for it themselves. In North Carolina, the program is administered by the Department of Health and Human Services, and it is means-tested, which means you have to qualify based on your income and your assets. Here is where most families get confused. They assume that because Medicaid is helping them, it is a gift, a benefit, something they paid into the system for over decades of working, and now it is their turn to receive it. That is not how it works. Medicaid is a loan. An interest-free loan, yes, but a loan the state of North Carolina fully intends to collect on after you are gone. Federal law, specifically the Omnibus Budget Reconciliation Act of 1993, requires every state in the country to have a Medicaid estate recovery program. North Carolina complied. The state is legally required to seek repayment from your estate for any Medicaid benefits you received after the age of 55 for long-term care services. After the age of 55. That is the number you need to burn into your memory. When you pass away, or in some cases when your surviving spouse passes, the North Carolina Division of Medical Assistance will file a claim against your estate. They have the legal right to recover the full amount Medicaid paid on your behalf for nursing home care, home and community-based services, and related hospital and prescription drug services. And what is typically the largest asset in a working family's estate in the Piedmont Triad? The house. The paid-off, mortgage-free, deeply personal family home that you spent decades building and protecting. That is exactly what the state is coming after. In Robert and Patricia's case, Medicaid paid approximately $118,000 over 14 months of nursing home care before Robert passed. The state filed a recovery claim for every dollar of that. Their home, appraised at $187,000, was the primary asset in the estate. Their daughter was looking at the very real possibility of having to sell the house her parents had lived in for 38 years to satisfy a government claim she had never heard of until her mother was already in crisis. This is not rare. This is not unusual. According to data from the North Carolina Division of Medical Assistance, the state recovers tens of millions of dollars annually through the Estate Recovery Program. The average claim against a North Carolina estate is substantial, often $80,000 to $150,000 or more, depending on the length and type of care received. And the families who get hit hardest are exactly the families like Robert and Patricia. Middle-income working families with modest savings and a paid-off home. They have too much to qualify for early Medicaid planning help, but too little to absorb the cost of long-term care without eventually turning to Medicaid. When families first learn about Medicaid estate recovery, their immediate instinct is to give the house away, to transfer it to the kids, to put it in someone else's name before Medicaid can touch it. I understand that instinct completely, but if you do that without careful planning and professional guidance, you can create a far worse problem than the one you were trying to avoid. North Carolina follows federal Medicaid rules that include a 5-year look-back period. That means when you apply for Medicaid long-term care benefits, the state looks back at every asset transfer you made in the previous 60 months, 5 full years. If they find transfers that were made to reduce your countable assets, they impose a penalty period. During that penalty period, Medicaid will not pay for your care, even if you genuinely cannot afford it yourself. The penalty period is calculated based on the value of what was transferred divided by the average monthly cost of nursing home care in North Carolina. If you gave away a $180,000 house 2 years before you needed nursing home care, and the average monthly nursing home cost in North Carolina is approximately $7,500, you could face a penalty period of 24 months. That is 2 years of nursing home costs that neither Medicaid nor your estate can pay, costs that fall entirely on your family. This is why the timing of any planning you do is absolutely critical. The families who protect their assets most effectively are the ones who start planning 5 to 10 years before they anticipate needing long-term care, not when the crisis is already happening. There is a painful irony here that I see play out for triad families over and over again. The moment of crisis, when a spouse has a stroke, when a parent is diagnosed with dementia, when someone can no longer safely live at home, that is exactly when families start thinking about these issues. And that is the worst possible time to be starting. Because the 5-year clock has to have already been running, there are some important exceptions to the look-back rules that can provide some protection even in a crisis situation. Transfers to a spouse are exempt from the look-back. You can transfer assets to a healthy spouse without triggering a penalty period. Transfers to a disabled child are also exempt. And there are specific rules about the community spouse, the spouse who remains at home, that provide some level of asset protection. But these exceptions have strict requirements and significant limitations. They require careful documentation and, in many cases, professional legal guidance to execute correctly. Getting them wrong can be just as damaging as not planning at all. And here is the piece that surprises most families in the triad when I explain it to them. The home itself is treated differently for Medicaid eligibility purposes versus estate recovery purposes. While you are alive and your spouse is living in the home is generally considered an exempt asset for Medicaid eligibility. The state will not require you to sell your home to qualify for Medicaid benefits while a spouse or dependent relative still lives there. But after you are gone, the exemption disappears. Estate recovery can now reach that home. The protection that existed during your lifetime does not extend beyond your death in the way most families assume it does.